Good evening and welcome to the Lopatcong Township Planning Board meeting of August 2015. At this time, I'd like to invite you to join us in a silent moment of prayer, followed immediately by the Pledge of Allegiance to the flag of our country. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. At this time, I'm required to state that adequate notice of this meeting has been provided indicating the time and place of the meeting in accordance with Chapter 231 of the Public Laws of 1975 by advertising a notice in the Star Gazette and the Express Times and by posting a copy on the bulletin board in the municipal building. Beth, may I have a roll call, please?
Yes, members Belcaro.
Here.
Weiner.
Here.
Dagan. Fishback.
Here.
Branch.
Here.
Rao.
Here.
Mayor McKay.
Here.
Vice Chairman Fire.
Here.
And Bentley.
Here. Beth, may move on to old business. Or before we go to old business, I'd like to state that we have received the resignation of Mr. Liptak, I think it was, as a alternate member, and also of Bruce Hall, who was a Class 4 member from the planning board. So they will be open positions. I don't know if the mayor is going to make an appointment for him or.
That would be done, of course, at the town council.
Okay. That being stated, we'll move on to old business. Has everyone received a copy of the minutes of the June 24, 2015 meeting? Are there any additions, corrections, comments? Hearing none, those minutes will stand as published.
Excuse me, I'm sorry to interrupt. Is there a public comment for the meeting?
No, ma'am. Just by way of explanation, I know we do a public comment meeting on agenda items before council meetings, but most of the time those are known entities that you're commenting on. We, as the board, don't even know what we're going to be facing because most of these are hearing items coming in. So in order to give the public a more informed information when they hear what's going on, we reserve it for public comment at the end of the session. I hope that explains the reason that we don't do it that way. So, okay, first item on the agenda is informal discussion on Block 94, Lot 1, Liberty Road, Lopatcong Township. Is that applicant here?
Yes.
Approach the podium, please.
I want 4 sets of plans. I don't know if you want them. If you like 4 of them.
Why don't you start by telling us what this is about?
No.
Absolutely. Some of you I know, some of you I don't know. It's nice to meet those of you who I don't know for the first time. I'm Randy Nelson. I'm the pastor of the Phillipsburg Christian Missionary Alliance Church. I've been there for 27 years in the same building. And we, in 2003, came to this board to ask permission to build on Strikers Road. We were unanimously denied. And I'm so glad that you did that. We found another property, and the board said if you find a residential property, we will be more than likely to allow you to build there. So the next year, at the end of that year, we found the property that is in question, and the board said you may proceed unanimously to the next step, which involved DEP, etc. Well, within a few months, we purchased it in February of 2004, and then in July we heard that the Highlands was signed, or in June the Highlands was signed by the House, but it wasn't signed by the governor until 2 months later in August. At that point, our property being the southwest border or the southwest line of the Highlands was not developable. Immediately went into appeal and called a state congressman that I had been friends with for years, and hired a firm that didn't do anything for us. Then another firm talked to us about filing in federal court, which we did 1 day before the statute of limitations was up. And It went to mitigation. The judge said, basically to the DEP, what are you going to do to make this right? We filed under a RLUIPA claim, Religious Land Use and Institutionalized Persons Act claim. Well, 10 years and 5 months and many gray hairs after they took the property from us, they granted us permission after a 37-page site plan was worked on hundreds of thousands of dollars later. So the DEP has given us approval on every page of that 37-page site plan. Still paying that down a little bit. But we're basically coming before you because we know that obviously you have been a part of this, at least in the wings, waiting for us, and as well as the county. We need to go through the county for the next step for us. So that's why we've asked for this informal under advisement, asked for the informal one rather than spending a lot of money and not having our ducks in a row. So basically that's where we are.
Mr. Chairman, I happen to have met with Pastor Nelson several months ago, and I had advised him to come to the board. This is a very unusual situation we have right here. Typically, applicants go to the municipal boards first, and you get their municipal approvals. The municipal approvals have conditions in them to go out and do a bunch of things, including getting outside agency reviews. And typically, they're handled in the latter stages of the development project. In this particular case, Pastor Nelson actually has a DEP permit, very difficult permit to get, but he doesn't have any local approvals. So I thought it would be wise for him to come just tell the board, a little bit about his project and maybe show the plans and make sure that there's no objections to what he's doing with his development proposal. So he knows that, and then we can start working with his professionals to put together a site plan application to the board. So that's really the background.
Okay. We really, if I can add, we really couldn't do anything until the DEP said it's okay, and it was a long process. I know you've never dealt with them, right? It's been a long, hard road because they give us a list of 30. We get all 30 done, and they said, well, off of this one, you need to do these 20. And it was years and so much engineering. So that's where we are.
So you have your approvals from the DEP and Highlands Council also?
The Highlands Council had to approve it before DEP would get their ultimate approval. Yeah.
So
they were really advisory, but they still need to be included.
Yeah, because we would probably have to
absolutely
get their permission before we could even review a site plan.
And I can give you all of their, if I can give them to you, I can give you all of the approvals from the DEP and all the statutes.
We will.
I assume what you got was a consistency determination from the Highlands.
He has a Highlands Preservation Area approval with waiver to avoid the taking of property. It's a major Highlands approval.
Okay.
To just give the board some background here, this site is in the R3-2 district, and churches are permitted principal use in the district. There are no maximum coverages in the ordinance, so the church actually could have theoretically 100% coverage on the site. There is no maximum. The DEP, however, has capped the coverage at 13.8%, and they're only allowed to have 4.12 acres of coverage. The DEP has pretty much spelled out various thresholds in the permit as far as how much in the way of impervious coverage, how much disturbance, how much in the way of building, how much parking, so on and so forth. There's various deed restrictions that they have to implement to protect wooded and forested areas on the site. There's a reforestation plan that's subject to monitoring over a 3-year period. It's a very, very strict permit. So, so there's very, very narrow thresholds. Again, the site's 30 acres. They're probably going to be disturbing probably a third. Maybe that might be.
Well, that would be
most,
impervious.
The impervious is only 4.12.
Yeah.
That's about 13.8%. So I don't know what the overall disturbance is. If it's
a lot of it's going to be, well, I think we did a 2 or 3-to-1 tree removal to replacement. They called that an upland forest, that tree line. For those farmers in this room, I was a forestry major at Rutgers, and I got my degree in that. I never saw a forest where you were in and out of it in 2 steps. So, but anyway, that's the opinion. I won't make any further comments.
16.2 acres of the site have to be deed restricted. So this is an area of the site that have so-called Highlands resources on them. So it's more than 50% of the sites going to be deed restricted. So it's a very, very strict permit.
Actually, more wildlife advantageous than what is there present with corn and trees. Wildlife vegetation throughout, all kinds of, every tree has its Latin family genus and species on there, as well as, and they even pulled some out because they didn't like these trees, and they told us what trees had to go where. It's very involved. God bless them.
Board have any members, any questions, or are we all familiar with where this is located at
I'm not really, I'll have to see it, plan eventually.
Well,
Oh, we
it's
will.
north of where Maury's Acres used to be,
Okay,
on 519.
yeah,
If you were to go 1/10 of a mile, there is a tree line that goes across the cornfield from Liberty Road, or I'm sorry, from Uniontown Road to Liberty Road, all the way across. That's one leg of our triangular parcel. Liberty Road makes up the other, and Uniontown Road makes up the other. So if you go to that juncture backwards, you have a parcel.
The only thing I would recommend to you, because I think there's very strict thresholds to see what you can build on the site. Both of the abutting roads are county roads. County's very strict as far as driveway placement goes. And you may want to have your engineer pay a visit to the county engineer's office before you file the site plan here in the county to make sure that they're satisfied with the driveway placement. We may have done that already for all I know, but if
I
they
know
haven't,
they've been
I would
kept
recommend
abreast
you
all
do.
along, but they haven't given us approvals yet, so. But they haven't stopped anything either, so I'm going to assume it's fine, but obviously we'll check it out.
The county has some very strict standards as far as driveway placement goes.
Any other comments or questions from the board? I think that your next step probably is you file a site plan, or at least the questionnaire that goes along with preparing to file the site plan with us, and we'll take it from there. At that time, when we file that questionnaire, when it's deemed completed, that's when our time schedules start kicking off, that we have review time and stuff like that. So I don't think there's any major objections that I see here from,
None.
you know,
It won't take 10 years.
continuing it, the building.
Lord have mercy.
Until we get the hearing on the site plan, and then that's open to the public, and your professionals will be questioned, and we'll take it from there, and then the board will vote on whether we would approve it or not.
Where would I go for those applications?
Right to me.
To our planning board secretary, Beth Diltz. She's also the municipal clerk, so we can probably contact her about any time.
Good lady,
Okay.
as you bless. There was one other question I had, and then it's page. Sorry about that.
That's okay. Any other questions we could answer for you?
You can call me anytime if you have any questions on the submission process.
Your card right on my computer.
Good.
So, gentlemen, I appreciate your time.
You're quite welcome.
Thank you.
God bless you all. Thanks for turning us down on the first property.
I think that was the Board of Adjustment, wasn't it?
Oh, I have 4 copies. I can leave 3 copies with you if you want, but I can make as many copies. My engineer will do them all at no charge for me, so I can have one in each hand if you want, but I don't want to do too many.
Why don't we save that?
Premature for that.
Beg
I
pardon?
think it might be premature until you submit an application, but certainly for you to leave them with our planner and our engineer.
Would
Okay,
be the best.
I will do that once we talk. Okay, but I can have everybody have a copy if you like.
We'll probably get our copy when you file the site
It's
plan. That would be
fascinating.
best.
Fascinating. Thank you, Jeff.
We're used to it.
Thank you.
Okay, next order of old business is ordinance 15-10, reviewed by the planning board as required under NJSA 40:55D, proposed amendment to chapter 243, zoning and land use, article 10, sign regulation of the code of the Township of Lopatcong. Does everybody have a copy of that ordinance? I'll open it for discussion. I should ask has everybody received a copy of it? We had a preliminary copy of it, I think, was emailed to us. Did you get a chance to review it all, read through it?
Absent anybody else, I have a couple of comments.
Mm-hmm.
At the last council meeting, I had the township attorney discuss this. Her opinion, it was not enforceable because it was not content neutral. And what that means is that any rule that applies to signs in the district has to apply to all signs regardless of content. I'm not an attorney. Mr. Spasaro is, so if I say something wrong, jump up. So she's drafted a second ordinance, and it's proposing an area not greater than 6 square feet. Anything over that would require a permit. I think the way it's drafted, it has a couple of errors in it. It talks about 4 square feet for real estate signs and being 10 foot inside the property line. And the very definition of contract neutral means real estate signs and political signs have the same rules. And I think that might apply to the next one. So that's my comment on the language. If it's going to be 6 feet, it's going to be 6 feet for everybody with no 10-foot setback. The other thing, and I don't want to delay this ordinance, but I'm wondering if in the future we don't consider a ban on all signs within the right-of-way, except for your normal traffic control signs. I think it would eliminate concerns about clutter, blocking of sight lines for traffic, that sort of thing. Now remember, your sign ordinance just doesn't apply to political signs, real estate signs. If somebody wanted to put up a sign that says "I love rabbits," they're permitted to do that as long as they comply with the ordinance. I think the business about the right-of-way, the DOT doesn't allow signs in the right-of-way other than their own signs. I believe the county doesn't allow it either. And again, I'm not an attorney. I was a planner for 20 years. I didn't practice at George's level. But I read a lot of planning material on signs. They're all written by attorneys. And it would appear the case law permits you to do that. So if not with this ordinance, perhaps we might ask the council to look at that in the future.
I also had the question about real estate signs being limited to, was it 4 square feet? Was it?
Yeah, and I think that's a typo, I'm sure.
But it's spelled out in here as 4 square
Yeah.
feet.
Mm-hmm.
And if we're going to, I guess we're also looking at not requiring a permit for any sign under 10 square feet.
No, I think
6 square
the-
feet.
6 square feet?
Six.
Okay. The original one, I think, said 10 square feet.
Mhm.
But, but that's been corrected to 6 square feet. I have no objection to it. But I think we should allow the real estate signs to be up to 6 square feet also.
It would be any sign, actually. You couldn't limit it to political and real estate and, allow somebody, make it residential for somebody else. And if you look at Katrina's email, there's a second half of this when you are allowed to regulate not the content, but the display, but those regulations have to be reasonable. And 4 square feet, if you had John Wisniewski running against somebody from the Ukraine or something, 2 long names, you couldn't read it. And the intent is to have it read on traffic. And Katrina said that she looked at a number at case law, and 6 was a reasonable number. So that's how she came up with it. I can't speak for her, but that's what was in the email.
Now, didn't Katrina say that she found the signs that we've been using for dozens of years are unconstitutional? She said.
Well, no, the signs themselves aren't, the ordinance is.
Well,
Yeah, yes, she did say that.
so I mean, because every other town seems to use similar size signs, and I didn't understand why we were going through this large expense to change the ordinance. If it,
But the ordinance was no good anyway, because it had different size limits for different types of signs. Churches could be 10 square feet. A birth announcement there was no limit on a birth announcement. And other signs were limited to 4 square feet.
I just wonder how the population's going to take that. I mean, a lot of people don't like the signs to begin with, and then you kind of increase their size by 50%.
Or, I have my comment, you have your comment.
Yeah, I mean, when you put
Council is going to get the comments and do what they will with them.
I looked at, I got Katrina's email, and I started to do a little bit of research, because she didn't cite any case law at all. So I started trying to do my own research, and I can't find anything where anything was struck down for the size of the sign. Content, yes.
The way you sit down.
Please.
Point of order.
You sit down.
Sit down,
Point of
please.
order. The Robert's rules, point of order is absolutely,
Sit down.
okay, you break it, I found a complaint against you guys.
Please continue.
Like I said, I didn't find anything on the size, so I wanted to ask Tony, do you have any case law to support this? Any of the cases that we can review or take a look at and read?
I've reviewed Katrina's memo. I also had the opportunity to review the cases that she reviewed. And I think it's beyond the scope of what we do here at the planning board. I think our determination has to be whether the proposed ordinance amendments are consistent with the master plan. I think that is the limit of our involvement in this. But for what it's worth, I share the same opinion as she does. As I understand it, the key issue, the determining factor, is that the size limits must be large enough to permit viewing from the road, both by persons and vehicles and on foot. Inadequate sign dimensions may strongly impair the free flow of protected speech, and I think this is especially true with political activity. It's my understanding that, and I don't wish to speak for Paul because he can and will speak for himself, but the township attorney did confer with Mr. Sturbins, and he was of the opinion, and I share the opinion, that 6 square feet was appropriate in order to meet that constitutional standard. I hope that answers your question.
Did she actually cite cases?
There's a case attached to her memo, and it is a New Jersey Supreme Court decision dating back to 1980, the matter of State of Milltown, State of New Jersey, by the Borough of Milltown versus Donald Miller. And just for a little comic relief, the sign in question in that case said, "Welcome, prospective residents of Lawrence Brook Glen. This resident and others of Riva Avenue want to welcome you to this flood hazard area. Good luck. Information available." So that, I guess, was enough to get under the skin of someone, but it went to the New Jersey Supreme Court, and I believe that is the seminal case in this area, and the case that was relied upon by Katrina Campbell.
Was that case, the summary of that case, based on size, or was it based on the content, allowing the free speech of the content?
I'm sorry, I didn't hear you.
The case, the summary, the judgment, was it based on the size of the sign or the content of the sign? Because all the research I've done, it's always content. Towns are always being slapped for limiting people's content. Even when the signs were over the size that they were allowed, the court always came back and said, you can't not allow them to have a sign because of free speech. It's the content of the sign. I don't see anything with the size.
Miller does address both. Limitations on size may be imposed if the allowable square footage is not determined in an arbitrary manner. The size limits, however, must be large enough to permit viewing from the road, both by person and vehicles and on foot. And regulations that allow only inadequate sign dimensions may be found to be an unconstitutional impairment of the free flow of constitutionally protected speech. And that is a citation to the Miller case. And I think it was based upon that language that, and again, I'm going to defer to Paul at this point, that Katrina conferred with Paul, and based upon that standard, it was the collective opinion and belief that 6 square feet would satisfy the constitutional requirement of being large enough that you can view it both by vehicle and on foot. And I think that's especially true if we're going to prohibit signs, although that is not technically before us, if we're going to prohibit signs in the municipal right-of-way. Paul, want to jump in here?
Yeah, I mean, Katrina asked me, one of the major changes to the sign regulation section of the ordinance had to do with the threshold as to when you needed a zoning permit. So Katrina asked me about the 4 square feet. And it's been my experience that that's a very small threshold. Some of the other towns I'm working with actually have 6 square feet as a threshold. So that's really why the 6 square feet was added into the ordinance amendment, was really based on those conversations I had with her. So I don't think we looked at the constitutionality of it. I was just telling her my experience in the industry and some of the other towns that I'm working in. Like, we looked very extensively at the Hackettstown ordinance, which is an ordinance I'm very familiar with, and it's 6 square feet.
Mm-hmm.
So that's how that threshold got put into the ordinance.
Along with some of my own questions on the liability of 2 foot by 3 feet versus 4 by 4,
Right.
I contacted the Board of Elections Director of Warren County. He put me in touch with an assistant attorney general in the attorney general's office. And concerning political signs or signs, it's basically up to the township of what size they want to regulate. However, she did indicate that 6 square feet seems to be, she didn't cite me any case law or anything like that, but it was her opinion that the 6 square feet was the minimum amount that you could match the constitutional requirements of the temporary signs, the political signs especially. That's what their opinions are going on. Most of the townships in New Jersey have the 6 square feet limit, and that's where it was left there. I don't think there's any definitive case law on it, but that's basically what they were putting the 6 square feet on, was the readability of the sign itself, and that's the answer I got back from the Board of Elections. So,
I think
for what it's worth.
I think there's 2 different things going on in the ordinance. First of all, you have a threshold for when you need a permit, and then you actually have criteria as far as what the maximum size of a particular sign, in the zone is to be. So I think people need to differentiate that.
But as I read this, there's no permit for 6 feet.
That's my understanding.
Correct. Went from 4 to 6 square feet.
They can be
Over
for any
6 square
purpose?
feet, you need a permit.
Well,
Yeah, I think. What? I'm saying you can put up signs that eggs are for sale and
Question
dozens of them.
for Tony, but the literature I read, you got to stop thinking about political signs or real estate signs. A guy could put up, "I love cats," or beware of child, or
And they can leave them up indefinitely,
they can.
and they get
they
that
can
size.
display
Is that right, Tony? Is that your understanding of it?
No, I think the understanding on the about leaving them up, there's a state law that regulates
For political signs,
specifically political signs.
they have to come down, right, yeah, but how about
Real
any other
estate
signs?
signs, I think 30 days or something like that, after the house is sold.
Where
or
is
the
that?
property sold. I
Is
think
that-
that's at the state level.
Well, we think, but we don't know. And any other sign apparently has no limit. So, by the way, this ordinance.
Again, that's
mean-
illegal. I haven't done illegal.
No, I agree, but I'm worried about, we're going all this trouble to change this law that's been on the books for, I don't know, 20 years, 30 years. I think we should try to address all the things that are, that should be addressed. And if there is no way to take, like, an individual sign that's not real estate and not political, there's no way to force people to take them down, and that would allow them to put up even bigger signs. Maybe that's something we should address in here.
Mayor, I
The
do
duration
think that
of the
perhaps we need to take a closer look at how this affects all signage, but we're coming up upon the political season. And I think the goal here should be to clean this part of it up, at least so there is no question on what candidates for office can and cannot do in this next election.
Well, there presently is no question, because we have an
But-
existing order.
But presently, there is a question, because in the view of the township attorney, and I happen to share that view, the ordinance that exists right now is not constitutional. So we're looking to avoid the cost of potential litigation involving this issue. We're looking to level the playing field for everyone that's involved, and to let everyone know in advance of posting these signs what is permitted and what is not permitted. We also need to, in fairness to the zoning officer, let him know where we stand on this issue. I think for all those reasons, it makes sense to move forward now, and I think it's the limited role of this body to decide whether it's willing to make a recommendation to the governing body that move forward with this ordinance.
Maybe I can add one other thing, Tony, and you are the attorney for the Board of Adjustment, but I reviewed the minutes for the June meeting. I was there at the July meeting. I thought the message was clear. The zoning Board of Adjustment is not going to enforce the existing ordinance.
Mr. Chairman,
Because before those reasons.
with that in mind, Mr. Chairman, I don't know if you want to open this discussion. It is a proposed review by the planning board. I think it would be appropriate to open it to the public and see if anyone from the public has anything to offer on this. But I would just say, please remember, we're not the ones adopting or not adopting this ordinance. We make a recommendation on whether it's consistent or not with the master plan, no more, no less.
I have no objection, so at this point, if there's no more comment from the board, I'll open it up to the public for comment. Mr. Rosen, or Marlo, would you want to?
Marlene Dick, 10 Byron Drive. Hi, Mr. Spazzaro. Nice to see you again. If you remember back a couple months ago, I attended the zoning board meeting.
I remember well.
Yes, and we had a nice discussion about the issue at hand. And at that time, you very clearly stated that this was an issue that really had nothing to do with the zoning board. So now what I'm hearing is, by some statute that's cited here, this has to come before the planning board. Can you explain what is the role of the planning board in this?
This is an ordinance that is part of the proposed ordinance that's part of the zoning ordinance, and under the municipal land use law, the governing body is required by statute to send that proposed ordinance to us as the planning board
Okay.
for review and comment.
Okay, for review and
After
comment.
we can take no action, but it's my recommendation to the board that you take a look at the ordinance and offer its feedback
Okay,
back to the governing
thank
body.
you. Thank you. I'm curious, this is on the agenda as old business. Was this an agenda item in the past?
I think that may just be an agenda issue is more than.
Yep, but I just want to mention that it is under old business. I just want to know if I missed this, if this had been on the agenda in the past.
To my knowledge, no.
Okay, thank you. So really, I did a side-by-side comparison of the two ordinances, and I have to say, I agree, the original ordinance is extremely confusing to a layperson, and I'll walk through some of those things that are very confusing. And then I read through the new ordinance, and it is just as confusing, if not more, at this point in time. So all of the things that are confusing before were not changed. The only real change that I see here is that permits are now required for signs that are greater than 6 square feet. Pretty much everything else is the same. So things that are confusing, like when I read under general sign regulations, when I read that language, it really sounds like everything is written there applies to non-residential zones. So it doesn't answer for me as a person who wants to put a sign on my lawn as a resident. Does this stuff apply to me or doesn't it? So it doesn't clear that up. Then when we go to signs permitted in all zones, it says the following signs will be permitted in all zones. It doesn't answer to me, when we say all zones, does that mean this applies to residential, everywhere? And it does still say, number A, point A, that signs not exceeding 4 square feet. So now we have an ordinance that was rewritten that still refers to signs being 4 square feet, and then permits being required for signs that are 6 square feet. So what happens if my sign is 5 square feet? Do I need a permit?
No.
I don't. Then why do I have language that talks about something not being greater than 4 square feet?
I'm sorry, where are you reading?
I'm looking at, in the new rewrite, it would be under, actually it comes up twice. The only time 6 square feet is ever mentioned in here is for permits. Everything else is not greater than 4, not greater than 4, not greater than 4.
No,
So
I don't mean to interrupt you. But
please do, if you can clarify.
I think I mentioned that. I think that's a typo.
Okay, so it's a
Because that would
typo.
violate the neutral content.
Okay, so are we doing another rewrite of this ordinance? But you guys don't have that. So you're going to render opinion, are you going to render an opinion on an ordinance that is just as confusing with typos in it?
We would be rendering an opinion with our corrections going up.
Okay,
We did not originate the ordinance that was
Right.
presented to the council.
okay,
So what we're doing is advising council what our thoughts on it.
Okay.
And what we think is.
That could be a comment of the planning board.
okay. Maybe in your comments too, can we actually get this thing written so it actually makes sense to a layperson? So I understand as a resident, if I want to put up a sign that says, I like cats, how big it can be? Because nowhere in here could I ever read this and understand that. So if we're going to go through the time and expense to rewrite this ordinance now, because we feel 6 square feet needs to be the new measurement, while we're at it, can we make this thing less confusing?
Bear with me a second.
Sure.
All right. It says, permit required greater than 6 feet. And
Yes.
And if you assume that the next two things are typos.
Which I would, because I got an ordinance
I'm
license.
assuming too, and
Okay.
that's going to be part of it.
Okay.
So you don't need a
Well,
permit.
Joe, where are you reading exactly? Which letter, which,
Well, this is the one that was emailed to me.
okay, so you have one that's not publicly available.
The two sections are 24353B, which is general sign regulations.
That's right.
There's a requirement that certain signs cannot be more than 4 square feet.
And it specifically says non-residential. So again, as a homeowner, I don't know what I can and can't do.
Only 55. So if you want to put up, I like cats, 24355 would not apply to you.
Signs permitted in non-residential zones.
Right.
This talks all about business signs now.
Right.
Again,
So-
I'm a homeowner.
Dash 52 is what
But it
applies
would
to
be
you.
in the-
So now I'm back to dash 52. Okay,
Yeah,
so,
it's 6 square feet. Our comments are assuming that it's 6 square feet across the board. That's what a content neutral ordinance is.
so you guys all understand that, right? Because I sure don't.
No.
I get content neutral. So if what you're saying, Joe, is every sign in the township, it doesn't matter if it's residential, political, I'm going to start up a new business, want to advertise it, they should all be allowed to be 6 square feet without any permit, then just write that. That's all. Just write it. Because, as I said, this is more confusing than the original ordinance. So if we can make it clearer, can we do that? And it's not for you guys, but when you write your comments to Katrina, you guys can do a side-by-side. You'll see very little has changed, except for the fact that a permit now is only required if the sign is 6 square feet or higher. Go ahead.
No, I was just saying, I think the only thing we were addressing was the fact that the constitutionality of the 4-foot sign
Yes.
was called in question
Yes.
for anything,
Okay.
and especially in the election signs that were here. And that's, I think, what the council is trying to correct.
So everyone's had a hard time, I guess, reading those who's running when they drive by. They can't read those names, I guess.
I think there was an objection made to the election board about that. So,
Okay.
Again, there's two parts.
Mm-hmm.
The first part is the way the ordinance was written, we had different square footages and different requirements for different types, for different signs,
Sure.
different content.
Sure.
So you got to get rid of that.
Let's do it.
Everything gets the same.
Right,
square
which is not in this new
All right,
ordinance.
now
Go
the
ahead.
second part is, per the law and per the case law,
Mm-hmm.
what is a reasonable size
Yes.
to convey your message? And I think Tony
Feels that.
explained that.
Okay. So Tony feels and Katrina feels that 6 square feet is like the best practice then for signage for a township.
Anything
That's the
smaller
maximum.
than that
Is,
may be
is,
constitutionally suspect.
okay. Constitutionally suspect. Okay.
that doesn't preclude you from putting up a 4 square foot sign if you want.
Absolutely, absolutely. But again, I think really my point is at this point, I mean, I'm over the whole, now we can have signs that are 6 square feet. If that's what you all want to do, you can do that. And I agree. Now it's I agree with you. It's important for everyone to understand what the rules are so we can all abide by them. My point now really is more that this thing's a mess still. So if you're going to go through this exercise of rewriting it, let's make it one that we can be proud of, because this is not good work. Thank you.
Thank you.
Appreciate your comments.
Thanks, Mark.
Olszewski, Highlands Way. For the attorney, just real quick, point of order, it's the resident's right to interrupt the meeting when things are not right, right?
No, it isn't your right.
What is
The
it?
chairman controls the meeting.
Okay, I will file a complaint.
Excuse me, you
Yes.
asked me a question, let me finish.
Good.
There's an opportunity for public comment at the end of the meeting.
Point of
You're al-
order,
Excuse me. You're also given the opportunity now to present whatever comments
Okay.
you'd like regarding this proposed ordinance.
okay, point of order, it's the resident's right to interrupt the meeting when it's not held properly. I don't think you know what you're doing. I don't think you know what you're doing, and you most certainly not. I will file a complaint. That first. Secondly, since you have sued or tried to sue our zoning board, what's his title? Zoning officer, if he enforces the law, and then you sit here and say it's not, or he doesn't want to enforce it, that's a lie. You and Mr. Bacaro tried to sue. With your involvement in the whole signage, because you screwed up your size and now try to finagle it so it fits your size, at least you should have the decency to recuse yourself from any discussions. People like you, we try to get out of here and not have more of. If you try to sue the town, you should not sit here and try to steer anybody in any direction. You have no right, and you should make sure that he and Mr. Bacaro have no involvement in the discussion of any sign issues or ordinances, since they are the one who threatened to sue the town. And that's my comment. Thank you.
Can I address that? First off, we didn't sue anybody. I said we, now, you've had your time, now be quiet, be quiet.
Don't.
This isn't,
Threaten to sue.
we run our meetings differently here. You've had your time, you sat down, correct?
Just don't lie.
All right, can we get him out of here? One more outburst and you're gone.
Yeah.
All right? It's my turn now. We didn't sue anybody, we appealed. And once we appealed, it was really up to the township how they want to handle that. It didn't go anywhere. So we didn't sue anybody. Secondly, there's no question, we were principals in that dispute. So is the zoning officer who sits on here, and I contend so is the mayor. Zoning officer works for the mayor. That's the way it goes. So 4 of us would have had to recuse. And I would have, if this was over that dispute. We've been given an ordinance for our comment. This ordinance goes forward. It doesn't look backward. And I feel I'm as informed on this as anybody else. And I'm giving my opinion. Now, we're not taking formal action. If the council wants to disregard my opinion, that's their right.
For what it's worth,
Mr.
I don't.
Sarah, you-
Yeah, for what it's worth, I don't think there's any conflict here. And although the township attorney can offer an opinion on conflict to vote on this because it involves political signs, if you take that to its logical conclusion, then no one on the council would ever be able to vote on an ordinance that applies to political signs because they're all elected officials. It's akin to a judge not being able to make a determination on whether judges' salary should be increased or not, or they should get certain benefits when there's a legal challenge because they may be affected by the decision. Sooner or later, someone's got to make that call. So that's my piece.
I'd like to make a comment that is based on the issue that we're not, I have no intention to sue, and we're taking advice from our attorney. My personal opinion is we were targeted because we went around and took photos and measurements of signs throughout the town that exceeded 4 square feet. So we were targeted only for our signs. So that means somebody's not doing their job enforcing the ordinance around town, and these signs are up all year long. So I have a problem with that. So either someone's not doing their job or they're incompetent, or they don't know what they're doing. We give them a directive and complain, okay, and you follow through. However, we were targeted because no other signs, no one else got any letter around town, all right, to say that they're in violation of the ordinance.
My understanding is that another candidate filed a complaint with Deegan, and Deegan went out and looked at it, and he made his determination. I never knew about this until I got it.
Mayor,
And this is
Handed to me at the council.
We need to do that.
with all due respect, I don't care who made the complaint. It doesn't matter who did it. The point is, if he's going to come out and enforce a particular sign, and this was never enforced in the past, never, and then target us, I got a big problem with that.
There was complaint files. How many complaints have been filed in the past? in which this
All right, I'm going to cut it off here.
That was the point.
We're getting way far what this board can possibly do, so let's move on. We have one more comment.
Just a quick thing, a little off thing. Ed Schuster, they were talking about being able to see the sign whether it's 4 or 6 feet. If we would all drive the speed limit, we could read the sign even if it's 4 square feet. Right here, it's 15-mile-an-hour speed limit, I believe. Who goes 15 miles an hour? I don't think any of them really. So my thing is, if no matter what size the sign is, if we go to speed limit in a car, you can read the small sign. If you walk it, don't make any difference. So if that subject does come up about the size, just think about that. That's a good point.
Thank you.
This board is not an enforcement board.
No, I'm just
We
saying,
want to talk
it's up to you,
enforcement.
just maybe mention that.
This board also is not going to make those type of decisions. We're here to review the ordinance as it is, and we will provide our comments up to the council who will make the ultimate decision. So I'm going to end this discussion. Is there any more public comment? Seeing none, we'll move on to the next order of business, which is the zoning history report for Block 1.
Before we do that, I think it would be appropriate if it's the board's pleasure to someone make a motion to adopt a resolution making certain recommendations with respect to this ordinance to the governing body.
Do I hear a motion?
What are the recommendations?
The recommendation can be either that it be it be adopted as drafted, that it be adopted with certain changes to make sure that it is content neutral, and that it is consistent with respect to size. I mean, given the comments here tonight, I think that is the thrust of what everyone wants to see. And I don't wish to speak for the board, I just want their advice. But that's my understanding of what I think this board wants. So for it to be content neutral and be consistent as to size limitations. And if that is your desire, I can craft a resolution, and I will also be in touch with Katrina regarding the shortcomings that you perceive in the ordinance.
I think there
With
should
that
also be
explanation,
finding in that,
someone make
so-
I will entertain a motion for that.
Paul has a comment.
Oh,
Yeah, just.
One item to put in that is that the duration that temporary signs can remain erect should be set forth in the ordinance. Now, we can, for the political signs, you can just reference the political rule. You know, for the real estate signs, apparently there is a rule for them. But for, you know, if I want to put up a sign with a, you know, silly face on it, leave it on my lawn for 6 months, I guess I can do that now. So, I mean, I just think that should be,
It's going back to the I Love Bunnies.
yeah. Well, you don't know.
Well,
Now they're twice as big, 50% bigger than they used to be. So it'll be more annoying, you know, for people to look at that crap.
Paul, you had a comment?
Yeah, I think that one of the main focuses of the board in this type of review is whether or not it is in compliance with the master plan or in conflict with the master plan. And I don't believe this ordinance is in conflict with the master plan, at least as I understand it. So I think that should be stated in whatever motion you make, in addition to any positions you take in the ordinance and any recommendations that you put forward to the governing body.
Yeah, a blank piece of paper would fit that definition too. So, I mean, if you're going to do something, why not make it as, you know, a good work product and craft it so it takes care of the issues concerning signs. That's just the way I see it.
So we first have to have is there any discussion on the motion or a second?
you have a motion.
The discussion, my point was to add a time duration for signs into the ordinance as a suggestion.
Time duration for what types of signs you can say?
Well, political signs have one, so
Yeah.
we could just put that in, you
Okay.
know, refer to this rule.
Right.
You want something in there with respect
Real
to
estate
the
signs
duration
have
of
one, but
temporary signs?
any other signs, any other temporary signs should only be allowed to stay up for whatever you think's appropriate, a month, a week.
If you're getting
That's a very difficult thing to enforce. For example, if
Yeah.
somebody has a sign at the end of their driveway, beware of dog. He's just gonna tell me he only have it up for 6 months. He's gonna have the dog for 12 years. I don't know how you can enforce that.
We have people who put signs out, curb your dog.
Well,
That's,
again,
it's permanent.
I don't know how you
I'm
enforce.
sorry, we need to.
Well, I mean, I just, you know, the way it is now, if somebody comes 40 signs on their front lawn,
So you
leave them,
have,
you
you
can't
have
say,
it in there, so if there is a complaint, you can act.
yeah.
But having it wide open, once you get in the court of law, how's that work out?
Well, again, I don't think something that's dependent on a complaint is going to meet the criteria.
I think we're at a point where we need to act on this motion, and Mayor, I will include in the resolution something concerning the duration of temporary signs and pass your concerns on, if that is the consensus of this board to the governing body.
Well, again, the case we brought up, I mean, if somebody says, you know, curb your dog or, you know, careful, you know, kids live here or something, that's not coming down in that.
I don't know if those are temporary signs, so I think
Then you'd have to define temporary versus.
we're going around.
This has gone on for years, this kind of thing. Well, I lived in Virginia and somebody put about 250 flamingos on their front lawn. And they made it a big issue. You know, they couldn't get them to take them down because there wasn't a specific law that forbade putting all that junk on your front lawn. And it looked awful. But for
Mayor,
years it was like that.
how about as a compromise? Let me suggest this, that we endorse the ordinance with the typographical corrections we talked about and suggest the council look at time limits for temporary signs and perhaps eliminating signs from the right of way as a future.
So eliminating what, the setback, 10 feet?
No, they'd have to be inside on the lot, in the property line.
Within the property.
Eliminates all that clutter along that.
But the right of ways vary,
Curb line?
don't they? They vary all over the town.
Not really. Of course, it's available on the tax map. Almost everything is 50 feet. There may be one or two that are wider. Well, most of them are 50 feet.
Is that now?
The right of ways,
Yes.
On lawns?
rights of ways.
So you have to put the signs 50 feet back from the center of the road?
No, the center of the road, the right of way extends 25 feet either side. And usually you have a 30-foot cartway. And then you have 10 feet in which you have a little lawn area. You have some utilities, you have sidewalk. All right, so usually a foot after the sidewalk, your property line starts. You would put it, for example, a foot inside the sidewalk. Be a lawn sign, as opposed to.
A lot of people put them on the ribbon.
Pardon me?
They put them on the ribbon.
Yeah, and I'm saying that's where you get into arguments with impairing sight lines and aesthetics and so on.
But
So,
people aren't going to understand what right of way means, and that's going to be, I think, a problem.
well, I don't think so, but you know what? I'll take that out if it makes this thing go forward.
I don't mind putting it in, but you have to define it so that people know what it is.
Oh, the right of ways are fine. We can educate people, and I'm saying we'll study it for future, just like we will the time limit on temporary signs.
Rather than slow this process down, I think the core of what this board needs to do is to make its recommendations on signs being content neutral and the size of signs. Let's start with that so we can get this ordinance off and running and get it constitutional for the upcoming election. And then we should and the governing body should take the time and the attention it deserves to get this ordinance right for once and for all. I think it makes sense for everybody.
You may want to define what 6 square feet is for the person who doesn't know how to do the multiplication series.
No, 6 foot square. A lot of people don't know what that means.
They don't. Trust me.
It's 6
It's
square
not
feet,
six,
not
it's
6
not 6 foot square.
It's
6 square
feet. That's what I'm saying, but there's an amount of inches that go with 6 square feet.
No, it's infinite. You can make it wider.
That's correct.
You
But
can.
when you multiply the two numbers, they can't be higher than a certain
They
number.
can't be higher than 6
I
square feet.
suggest that you maybe put that in there.
The chairman made a mistake. When the chairman said 4 by 4.
Correct. It's not 4 by
It's not 4 by 4. It would be 16
square feet.
Correct, it would be 4
So,
square feet.
just so there's no confusion.
But the way it's stated in the rules, a lot of people don't understand that.
I want to just explain.
We heard about it, believe me.
Motion second.
Well,
I'm waiting.
we got to hear the motion.
I thought you said,
The photo on the wall is approximately 6 square feet.
The,
3 feet by 2 feet.
do I hear a motion, Ellen,
it's
with
not
Tony's?
6 square feet.
The square foot discussion is now over.
You know what, the explanation doesn't have anything to do with the planning board, the council can correct that. I'd say I'll make the motion that Tommy stated, and we approve it with the corrections to make the dimensions and everything, to make it content neutral and make the dimensions conform to a minimum of 6 square feet.
Fair, second?
Did you say minimum or maximum?
Maximum.
Square feet.
Without a permit.
Without a permit. Without a permit. I'll second.
Roll call vote, go ahead.
Members Delcaro,
Yes.
Weimer,
Yes.
Fishback,
Yes.
Grant,
Yes.
Burrell.
Yeah.
Mayor McKay.
There's one other thing. Oh, I can't add, right? No.
Vice Chairman Pryor
Yes.
and Chairman Bentley.
Yes.
Just one little side note.
Carries.
Motion carried.
Thank you.
The side note is, what are we going to do with these awful sons of guns that are going to put out 2 foot square signs? Or 4 square foot signs? They're unconstitutional. Should we rip them out?
They're not unconstitutional here. What is unconstitutional is limiting people to 4 square foot signs. If they want to put up a 4 square foot sign, they can do so, and they don't need a permit to do so if this ordinance is.
Yes, but they're hurting the public because people are going to car accidents trying to read them and all these reasons that you gave. I think we should outlaw signs that small.
There's case law out there when I was doing this research,
Yeah.
which towns tried to use that card.
Yeah.
It didn't fly.
All right, you'll draft the resolution on that and come back and
4
we'll,
square foot sign and a 6 square foot sign.
What?
The cost is to be a big difference.
Cost?
Yeah, and the 6 square foot sign.
They're not
versus
much
the
more.
4 square foot sign.
They cost more?
Yeah, much more.
I don't know.
They cost the same.
we're not in the business of discussing cost on signs, so let's move on.
Okay.
We have the zoning history report for block 116, lots 26.01, 27, 27.02, and 28. George, would you outline that for us, please?
Yes, the board has in their package a draft, well, not a draft, it's an actual report on the proposed rezoning of what historically has always been called the Piazza Tract. As you're well aware, Mr. Larkin had come in and requested that the board consider a rezoning request to change the HB zoning designation to permit multifamily housing. What this report tried to do was to take a look at the proposal from the developer in the sense that he put forth 2 conceptual plans, one called Conceptual Plan A and Conceptual Plan B, that involved, one was a mixed-use plan that involved 175 multifamily units, along with retail on the Route 57 frontage. The others was a 100% multifamily project, 199 units, with no commercial activity. And along with that, there were comparisons made to the existing HB zoning district. What this report attempted to do was to look at various elements in the town. It looked at the historic zoning of the site, that is to say the HB zoning, and essentially why it continued to exist at that location today. And then it began to make comparisons between the alternative plans that the applicant, or not the applicant, but that was being requested as a possible site design for the site, and the available infrastructure, traffic, sewer, water, and finally fiscal in terms as it related to school children generation and possible impacts on the school system itself. Essentially, the HP zoning district, and many of you were here for this, went through several configurations over the years. The zoning that's been in that area has been there for many, many years. It actually predates my involvement with the board. But we did do a rezoning several years ago that basically reduced the amount of HB zoning in the town, particularly as it extended down 57 and headed out of town, essentially into the farm country. We pulled all that back, and we retained the zoning on the corner, which is the subject of this application, Strikers Road and 57, as a potential spot for neighborhood commercial zoning, because it appeared to be associated with both existing commercial that had developed in the area, and also that it appeared to be compatible with the multifamily zoning, the commercial uses in the area, access to 57 and abutting streets. We did feel it was a compatible use. As you're aware, we're being asked now to consider rezoning that tract for multifamily use. Our general discussions here as it relates to compatibility is that the proposal to change the zoning to multifamily remains compatible with that location. That is to say that the shift from a larger commercial area to a multifamily area would not result in any particular type of incompatibility with the surrounding land use, which is essentially commercial and multifamily development. We also felt that the local traffic and access system, the surrounding roads, were adequate to handle the traffic that's going to be generated, though it should be pointed out, obviously, that the commercial development that is being proposed, if it was fully built out, would actually generate the highest rate of traffic and impact on the surrounding streets. And that what the Larkins are proposing, the two alternatives, obviously the mixed use plan would have the next highest level of traffic and the pure residential plan would have the lowest level of traffic. So that the proposals, if you're going to make a comparison there, the as-zone plan would actually, if fully built out, would generate more traffic on local streets and on Route 57 than either of the two proposals that are you're asked to be considered here this evening. From the standpoint of utilities, we went through an analysis, and there it works exactly in the opposite. And what we were saying there is that, and we had discussed this at various planning board meetings, the town does have a general cap on how many gallons are available for future use for development in the town. And this tract of land is not in the wastewater management plan. And essentially what we have estimated here is that currently we have about 44,500 gallons reserved. We're reserved for the data center. And if we add that into, I'm sorry, I'm getting my numbers.
39,000.
Yeah, 39,140 gallons is what is currently available in the plan. The data center, which is not in the cards anymore, would add another 44,000 to it, so that the town would have available for future development about 83,640 gallons that has not been allocated. If this project was to go ahead, as I said, it would work just in the opposite, and that is to say that the all commercial, if it was left as zone, we'd be using a little over 9,000 gallons of that capacity. The mixed use development would be around 36,000 gallons, and the all residential project would be around 40,000 gallons, 4,500. So what you can see is that the shift from a commercial project to a residential project will have a direct impact on the future gallonage that may be available to serve other projects in the town that are not perceived of right now or are included in the wastewater management plan. The other aspect of the project was looking at the schools, and the applicant had submitted a report that began to look at the potential impacts of these two alternatives on the school system and whether or not it had a positive, negative, or basically no impact on the local school systems. Our evaluation of that report was that the estimate of school children that they put in the report itself was very reasonable and conservative in actual fact. We would agree with the methodology that they used, that they came up with the school children numbers in the report itself, which was to generate between 23 and 26. 23 and 26 school children coming out of the project for grades K through 12. Where we did suggest that the board might want to ask for additional information, though, is in terms of how the impacts were calculated. One of the things that we noticed in the report was that the Lopatcong Township has both their, well, I'll call their elementary school system, and then they have the Phillipsburg school system, and you're sending children to both. The report itself appears, at least in reading it, that the only thing that was considered was the township side of that equation. There was no calculations in there determining, one, how many school children out of this project will end up in the regional high school system, nor were the economic impacts of that included in the report. So we feel that the board may be justified in, quite frankly, asking for some more detail on that evaluation that would actually look at those numbers of school children, how they were distributed, and then the costs allocated based on the local school system and the regional school system. The other aspect of that analysis that we thought would require some additional look-see was that there was an assumption built into the calculations that said that the cost of educating the new children coming into the system would be exactly the same as that is currently bore by the township tax base. And what they're really saying there is let's say that it costs $12,000, $13,000 to educate a grade school pupil. Today, only $9,000 of that is supported by municipal taxes. The rest are supported by other forms of income. What that does from the standpoint of looking at the finances, it's making the assumption that one, current funding will always remain the same. That is to say that the monies flowing in will always remain in the same proportion to the number of children. So that one, there will be no reduction in support, say from the state or from other people, but also it assumes that for every new child you add, there will be additional state money to keep that balance. And I would think that it would be fair to ask the people in this case to look at this in two ways. The way they have looked at it, which is generally fine, but also to look at it assuming that there would not be a growth in state subsidies. That is to say that the kids coming in have to support themselves. And what that'll do is give the board a good idea between the potential side of it versus what it might be if everything remains consistent. So we felt that the board may wish to ask for more detail on the school enrollment side of this. The other aspect that in making the decision in terms of whether or not to rezone the property that we should keep in the back of our mind is that historically the master plan has always wished to encourage non-residential development, but the town has absorbed over the years many residential units. And there's built into the master plan was a desire to increase the township non-residential ratables, quite frankly, to help generate more support for the schools and help to maintain the municipal budget. The loss of this 16-acre parcel is not a huge loss as it relates to the HB district. It's only about a little over 5% of the district. But one of the things that we thought is important to consider is that the largest non-residential portion of the tract is the Ingersoll piece. And how that goes in terms of commercial development versus non-commercial development in that area may play an important impact in terms of whether or not you will have commercial ground available for future development. If you take the Ingersoll tract out of this is probably one of the few remaining undeveloped commercial pieces that you still have in town that can absorb it. It's also located at an area that I thought, in terms of the master planning of it, would be a good place for neighborhood commercial. But I think what the report basically concludes is that what the applicant is asking for is compatible with the area. There is sufficient utilities to support it, but the shift from commercial to residential will have a cost in terms of eating up the gallonage that might be available for other development in the town. And that it also will have a cost in the sense that it will eliminate a fairly substantial size of potential neighborhood commercial. One of the recommendations that we had in here is if the township is inclined to grant the request for a zoning change, we felt strongly that it was important that there still be some commercial context on Route 57. And we think that that quite frankly, there should be reserved at least the frontage on 57 for commercial, even if it's felt that the residential is appropriate in the back. We also felt that the interlinking of the streets, which is part of the plan that was presented to us between the various streets, is a very positive thing, because the more we can distribute the traffic out to more streets, the less impact it will have on any one street. We did feel, though, that if the first alternative that involves no commercial is approved, then I'd see very little reason to have a connection to 57. If we're not going to develop that commercially, then quite frankly, internalizing the circulation to me seemed to make more sense than creating another intersection on Route 57. So in general, I think our report shows that overall the impacts of this proposal are manageable. There are costs involved with it, primarily loss of commercial ground, impact on our available sewer capacity. And quite frankly, I think that the impact on the schools hasn't been well enough defined yet. And I would think the board would be well within its prerogative to ask the applicant to do a little more work on the school impacts part of this report, if they decide it's worth going forward with it. And that's it in summary. You've had it in front of you. I'll try to answer any questions you have on it. It's not a very lengthy report, but I'll try to take a shot at it.
I do have a few, George, and I wanted to let you finish, and I like the report. I think it's very well done. I had a few questions on the utilities. I have different numbers than you for a lot of these things, and I'm not going to go into that here, but I'm working with the version of the wastewater management plan that was approved by the Highlands, and I'm not sure if we're working off the same edition. Maybe we could reconcile that.
Well, if there is, we'll reconcile it.
Yeah, the other thing, I'm coming up with different flows for, I took the DEP flows, I put them against 169 two-bedroom units and 30 three-bedroom. I got a higher figure than you. But we can reconcile that. But you're saying it does not include any of the properties that the WMP doesn't include any of the properties. It doesn't include them in the current stored area. But it does include this in the future stored area in the same manner it does the Ingersoll tract.
Well, that wasn't clear to me that there was a reserve for this.
No, it's not reserved. But I mean, when you color the areas to be stored. And I think the Islands noted that at the time that there was, as a matter of fact, we've had this discussion before, there's more area that can accommodate development than there is sewer capacity to go around. And,
yes.
and they said, you're going to have to deal with that. So I don't know if that makes sense. It is colored yellow on the future sewer map, the same way Ingersoll is.
Yes. But there's no all I'm trying to say.
There's no allocation.
There's no allocation
for it.
for it.
State that a little different.
Okay,
Make it clear.
All we were trying to say is that this would have to come out of what is left.
Yeah, right.
That's all we were trying to say.
And maybe you could just
tweak
that a little bit.
Sure.
I do have two other small comments, all related to the sewer. There are 20,000 gallons under dispute. It's noted in the master plan. So let's pick a number. Let's say we had a balance of 40. We may have as low as 20. If we lose on the dispute, it could be less than the 40. So
okay.
We have a range there. And there's a footnote on the master plan.
I'll get you.
Yeah, thank you.
The other thing I'd suggest you may want to add is we do have sewer lines available. They're there. We don't have a limit in our contract with P-Bird. There have been allegations by P-Bird of limits on downstream capacity, so the connection's not a slam dunk. We'd still have to get a TWA from Phillipsburg, and maybe we might need some work either with II or improvements on the downstream sewer. So
okay. Well, I've noted that there is sewer adjacent to the property.
Yeah. You might just add a few words that the downstream capacity is yet to be determined.
Okay.
Something like that. Paul, you agree?
I agree with everything you said.
The other thing I do my feeling is what George expressed. We have a limited area remaining where we can have commercial development. It's also obvious we have limited sewer capacity remaining to serve. You know, if we devote that all to residential development, that's that much less sewer capacity available for commercial. So if it were between these two alternatives, I would personally favor if we could do something with that parcel along 57. I understand that, you know, the strip mall type store isn't doing well, but daycare seems to be doing very well. Medical seems to be growing. Dental. And I was thinking something along the, you know, something professional as opposed to a strip mall type use. Even legal, we seem to have plenty of demand for legal in this area.
This isn't exactly concerning the report. However, as late as August 14th, we were notified by the Highlands Council that the regional master plan for the Highlands is going to require us to reevaluate Module 3 housing element in the fair share plan. And the Highlands Module 7 implementation plan and schedule. Since this is going to, or is proposed to be, an inclusionary housing development, I'm wondering, until we get a number foisted on us by either COA or the Highlands or the Supreme Court, where it resides now, we're not going to know what we're going to need in this township as far as COA units are concerned.
I would agree until this is resolved by the courts and the number and how this fits into that is going to be up in the air.
I understand also that we Mr. Larkin, I don't know, I guess Larkin's attorney has indicated that they are now intervening in Lopatcong's action with the Supreme Court for COA obligations for the township. I don't know where that's going to leave us, where that's going to put us. And we're starting to hear numbers come out that are way beyond what we thought we were going to be getting. So I really don't know how would this impact it.
Well, I don't know how it's going to impact the final numbers because none of us know what they are in the end. Clearly, if we were to proceed with this, the applicant, I shouldn't say the applicant, this is not an application, but in this case, the proposals before the board both involve a percentage of affordable housing. They're not requesting, but indicating a willingness to provide up to at least 15% of the units as affordable. So they would be providing some units as part of this proposal, which, you know, whether that is substantial enough to impact the final number or whether, as we at least believed, we already have a surplus. Whether that remains, we'll find out. So all I can say is that they are offering to provide affordable housing. What the impact is on the final plan, I really can't tell you because we don't know the final number.
No other questions?
Well, I'll just throw out some thoughts. I mean, listening to the whole thing, I mean, I think I kind of agree it is a good place for non-residential, you know, in the town. I don't know, there's no crystal ball to see what's happening on the Ingersoll track. There's no way of knowing that. So if that doesn't go in a certain direction, we have very limited highway business available in the township. And to give that up, I don't know that's a good idea. And so that's one thing. The other one is, the sewer allocation. If this is going to eat up majority of the allocation that we may or may not even have, that's another undesirable with changing this away from highway business. And I think having, whether it's professional buildings, medical, those types of things, it is a good location in the township to do that. So to me, I think I'd rather see it stay as highway business.
There, any comments?
I concur that highway business is an issue, and to preserve it, I think, is a good idea. We don't know the sewer capacity. We don't know what is going to happen when Ingersoll Rand. Although if you come around tomorrow, you'll hear more. And they'll need water too. So, and sewer.
And that Ingersoll tract's been discussed for many, many, many years.
Oh, yeah.
So there's no indication on when that would be settled one way or another, what's happening. I think to give it up today would be a mistake.
All right, well,
Yeah, I would concur with Fred that when we sat here years ago and put the master plan together, there's some reason to use that in the highway business area. And I don't think anything's changed. I would say we should change that.
nothing else, shall we forward the report to council for their consideration? That's what we were asked to do.
Yes, if the board desires, I'll contact with Paul, Joe, and get the right numbers in the report for gallons, so we're all consistent.
Okay.
Make the report available to the public.
And yeah, once we get it out, they will make it available.
Excuse me. My regard, Mr. Martin, came here to knowing about the report and not knowing about it. I don't think the discussions of what you people felt that we should and should not do. I asked Bob Heidel, the engineer, the chief engineering. Now, to come. So there were certain questions that I can't answer, which I never could. The questions hopefully will answer. I'd like to, I know this is not one of those meetings that you have left, you normally have. I just felt that if you were finding questions that were outstanding and whatnot, that if you wanted clarification today from any of these reports, I have two gentlemen who are here, and you can ask them whatever you like to ask them. And you can know the things that you want, that you're concerned about. And my opinion is you can solve those problems. So if you have any questions from Mr. Heidel or I, it's up to you.
I have none really. I mean,
Well, it's really up to the board whether they want more information in regards to the schools, that type of thing before we go. That's really up to the board to make that call. In terms of,
well, I'd like to forward this up to the council with our concerns on it. And if they want to continue with this and go this way, so be it. I mean, we're not making the decision here tonight. As Mr. Larkin just stated, this is not a hearing or a site plan hearing or anything that we're doing here to make the final decision. So
we had the opportunity to hear, obviously, all the comments. I don't think that we disagree with any of the facts contained within the report. It appeared to me that the only request from Mr. Ritter was regarding the school, and that would be to go back to our consultant, Mr. Reddy, and furnish you with that. The information on Ingersoll Rand, it's factual information. We certainly have no control whatsoever over that piece of property. Facts containing the sanitary sewer are accurate. Whether or not the numbers look at this or look at that, they're generally accurate numbers. We don't dispute that. There were two projects that we proposed. One had what we considered to be a 2-acre commercial portion of the HB zone, which we then requested were to rezone, and the remaining 14 acres would go to the residential component. The other one had 100% residential component. I think from the discussion, the board would rather have at least the 2 acres, which is along Route 57, remain in the HB zones, and certainly the applicant can do that. Once again, the applicant certainly does not want to build the non-residential. He has this here. The property is under contract, and it's his desire to go ahead with one of the residential projects. So that's why we're trying to get a feeling of where this is going. The board asked the last time I was here on 2 or 3 occasions on this, why didn't I present a plan showing 90,000 square feet? And the answer was, Mr. Martin, Mr. Gardner, Martin Associates, is just not interested in constructing 90,000 square feet of retail on that property. That's still factual today. He is interested in building one of the other 2 options. And so we're trying to get a feeling where this is going. And if you feel that you can't make a decision unless we go back to Mr. Redding and get him to supply additional school information, we can certainly do that. But quite frankly, if that's wasting our time, we'd also like to know that. I can't do anything about the sewer. I can't do anything about Ingersoll Rand. And there was only one question.
I realize where you're coming from, but we are basically in a conceptual overview right here. This board will not make the ultimate decision of whether we're going to zone or not. That's strictly up to the council.
I clearly understand, but without a recommendation from the planning board.
I'm looking from the council side to which way do you want to go?
Well, council didn't ask for a recommendation. Council asked for a report right now.
A history.
And I think we're fulfilling that request. So I think the proposal is, important.
As I say, I hate to put you through the whole operation of submitting site plans and what we're going to do. We go through the exercise of reviewing it, and then we ship it up to council, and it gets shut down. I'm trying to find out what does council want to do with this property from the overall viewpoint of what's happening to this township. Cullah, Highlands, commercial development of the Ingersoll Rand property, which is under some discussion right now, where it's going to go. Nobody here knows what's going to happen on that one. Our sewer capacity, impact on the schools, I think. So I think we're still trying to sort out what we're going to do, where we're going to do. What we're being requested to do by Highlands now is to review everything that's affecting the fair share housing module that we had to fulfill for Highlands, and they're giving, or Cullah, I should say, I'm sorry, and they're not giving us any figures right now. I mean, we've been going around and around with this since 2004. We thought we had something coming up when the Supreme Court declared round 3 and 2. I'm sure you're well aware.
I'm well aware of this municipality and many others.
So, I mean, until we get an answer of exactly how many units are we going to be required to provide, we look at our township as saying that as far as residential is concerned, we're sitting out on Red School Lane with a 600-unit apartment complex with Berkeley Gardens that we can't get a COLA obligation for, even though it's rent control. So, I mean, I think we've provided a lot of our own affordable housing in this community. It's not recognized by COLA because of the deed restriction. And, I'd love to give you an answer if I had the answer. So that's about where we are.
So do you think it would be valuable information for you to go back to Mr. Redding to get that school information?
I would like to see a little bit more information on the school costs.
I'm trying to keep the ball rolling.
Oh, okay. I would Well, George, that's one of the things we.
Well, I would think that that would be helpful if the board would like to see that range and get a sense of where that is. I think that would be helpful. I would assume, by the way, that, along with the board's review of this report after tonight, we can release this to them so they can actually see it. I have not released it to them, this report yet, to the public, because until the board heard it, it really wasn't public. But I'll be glad to release it, and they can try to address anything in here. The schools are the main issue.
But there were certain issues that Mr. Pryor brought up that you wanted to reconcile?
Well, I want to get the numbers so that we finally all agree to it. We're all within a couple of gallons, but the answers, they don't match.
And
So
I
I want
agree
to.
with this part. There should only be, in my opinion, one set of numbers.
Yes, well, that's what I mean.
State has a gallonage for each of these types of.
Yes, I thought I had them, but
Yeah,
obviously we'll get them to match.
We probably have two different, two different dates on the
It could
master
be.
plan.
We'll get them to match.
One set of numbers from you, and
That's what I'm saying.
if
Yeah.
that, I didn't even want to get into details here.
Yeah.
They'll get reconciled.
Right.
I think it's more what you are in the future sewer service area. It's just a question of the allocation more than that. And then there are some issues with downstream capacity.
And I understand that also. So I'm not disagreeing with any of the statements, but I can't cure all that. That's it.
Well, the council asked for a report. That was all they asked for, and that's
what
what
we're
we're giving them.
delivering.
So it seems to me,
Do you want to rework the numbers on the schools then?
No, I prefer that they
Oh, I'm going to say
rework,
they work.
rework the numbers on the school. But I don't think that necessarily would stop this from going to council unless they want to get it to me, and that's your call. Should they get that to me before it goes up to council?
Well, keep the discussion going between our professionals, and that's where we'll get the answers from. So I think we should send the report up to council if the rest of the board agrees.
So do we provide any recommendation to council or not?
No, the
We're just going to
report,
put the report speak for itself. That's what we're giving them. We're not making any recommendation. We weren't asked to do that.
So will council come back and ask?
it's up to council.
They get the heavyweight.
Right? If you want us to investigate more, you'll send it back down with a request, right?
We want you to put those updated capacity figures.
That'll be done before
We'll
you.
make it a working process. In progress that we all agree on what the numbers
So
are.
I'm going to assume that you're going to get the sewer numbers so that
Oh, yeah.
everybody agrees. And in the interim, we will go to Mr. Redding and we will ask him to supply you with the updated school numbers.
I think
Using
the
the
way
actual
George
cost.
worded it was the council should ask him to update.
well, I said that, yeah, we
Yeah.
ought to be asked to upgrade it. It doesn't have to be done now. It's just that I think it would be
Well,
it would
council,
give people a better idea of the range rather than.
you're aware of our recommendation there, and you can do that.
The applicant would like me to repeat one statement that I made, and I thought it was clear, but apparently it's not. We would take off if that's the desire of the township, either the council and or the planning board, the full proposal for the 16.6 acres and consider just the 2 acres of commercial that's left alone. That'd be 7, if that's the desire of the township.
That's what we were just trying to determine. So.
So I'm saying we proposed it 2 ways because I started with 1 way. Then when I came to the board, there was a discussion about the potential. So we proposed it both ways. So we didn't take one off the table. I said, here's the way it works in case 1, use 1. It works in case 2.
Thank you.
Thank you.
Excuse me, I have one other, I was on my plan. It says it's question as much as maybe it's his favorite, just listen. I wasn't getting a feeling, but he had a feeling with reference to it.
If he doesn't speak, do you get a rebate? If he doesn't speak, do you get a rebate?
I'm working on
No.
it. Didn't wish he did it, so, just clarification.
The board's been very patient with us, and certainly we all appreciate that. And I've had some good conversations with George, and there's nothing in that report that troubles me, frankly. The only thing I would add is George made a recommendation that if you rezone the site, that the applicant should be building housing instead of making a payment in lieu of housing, and we agree to that. So I just want to be clear that we would agree to the mixed-use concept with a set-aside for affordable housing. I think, that the other thing that I would agree with is that we don't really know what your housing obligation is. I think I know it's going to be pretty big, but you don't know that yet. George doesn't know that yet. And, but I think eventually you're going to find that this is probably going to be part of the way that you're going to respond to your housing obligation. But that'll play out, and I think what's encouraging to us is how collegial this process has been, and I thank you for that.
Thank you for your patience. I wish we had more definitive numbers to work with.
You tell Larry he can't shoot you down in the streets now.
Okay, we'll go to the. I guess we can open it up to public comment if there's any more public comment.
I have more public comment. Chesky Highlands Way. First off, since you guys lecture me about running a proper meeting, I would appreciate if you apply all these statutes to everybody. None of the gentlemen came forward. None of them stated their names. It was not on the agenda. I don't think that's a proper meeting. Should have done differently. Second, I would like to state, I'm not sure why we're paying our attorney to draft a resolution. I think we pay him for it, for a thing which does not belong in front of this board here whatsoever. Just because an engineer and a carpenter are not able to measure 4 square feet, I don't think that the taxpayer should have to fit the bill for anything. While I believe that he enjoys it if he's working towards a new E-Class, I, as a taxpayer, I don't really want to pay for it. And to just clarify one more thing, I didn't say you sued the town. I said you and your sidekick, Lou Belcaro, you threatened not only the zoning officer, but also the mayor, that if they would take action, you would sue the town and your own employees. And that's what you do. If you start twisting people's words before you're even in office, I don't want to know what you do when you're in office. Thanks.
Any further comment? Seeing none, I'll entertain a motion to adjourn. Motion. Second. All in favor? Aye.
Aye.